Discuss the legal procedures for securing admissions and confessions. The law of evidence as it relates to statements made by the accused is criminal case is commonly known as the opposing party statements or admission and confessions. There are certain conditions under which confessions are constitutional. There are certain rights the police must provide to the accused before any statements can be taken. One is the Miranda rights, which must be read to the defendant before questioning. Another is the Sixth Amendment to the U.S. Constitution that guarantees right to counsel. Sometimes confessions and admissions frequently overlap, and it is difficult to decide if the statement is an admission or confession. It is said that a confession is an admission of crime itself, while an admission concerns only some specific fact, which in turn tends to establish guilt or some element of the offense. I would define admission as an out-of-court statement tendered to prove the truth and contents that it is adverse to the interest in the maker of its admitted because it is reliable. I would define a confession as it is an admission of guilt that goes directly to culpability by ways of words or conduct. For a confession to have been freely and voluntarily made, the person making the confession must have been in position to exercise complete mental freedom at the time that the confession was made. The courts have been strict in their implementation of what will affect this complete mental freedom and has ruled that pressure applied to introduce a confession will be considered as an interference with mental freedom and cause the confession to be excluded from evidence of trial. The requirement that the confession must be given freely and voluntarily satisfies two concerns of modern jurisprudence. One is, unless the confession is so given, there may be no doubt about the fundamental fairness and is used at trial against the accused. Second, unless it is given freely and voluntarily, the accused's rights against self-incrimination may be violated. Statements or act by an accused before trial that is not an acknowledgement of guilt but do link the accused to the crime are in some ways incriminating are admissions. The accused need not intend to incriminate himself or herself for the statement or act to be an admission. An admission may be a simple acknowledgement of being at the crime scene or being acquainted with the victim of the crime, or even denial that the defendant was at the scene. Acts are also classified as form of admission if they are inconsistent with the accused innocent. Acts such as trying to escape detection of arrest or hide a crime or admissions may be introduced against the accused at a trial.